Well, greetings again. It's time to have more fun and games with the IRS and with your government agents. This is going to be lesson 13, and we're going to talk about motions. Now, motions represent 50% of your entire case. So if you can't write, you're in real trouble. If you're a functional illiterate who's come from our government schools, well, you've got a real problem. And that's why we came into play and put all of these motions and all of these legal arguments in our computers so that we can pull these arguments and briefs, affidavits, etc. out of the computer for people just like you who are functional illiterates who know about 2% of the English language. I was talking to one of the fellows here this morning. I said, how would you like to get on Eastern Airlines and have the captain come over the intercom and say, ladies and gentlemen, we're having a little problem landing the airplane here today. It seems that we only recognize 3 or 4% of the instruments here in the cockpit, and we're having a little problem here finding the altimeter, but as soon as we find the altimeter and we get the fuel flow under control, we'll probably attempt a landing. And that's about the way the average citizen is when we're talking about words and definitions and processes and procedures in the courtroom. We've all been to the government schools. We recognize about 2 to 3% of the English language. We get into the courtroom, and we're up against paid professionals that have been to law school, and they speak a different language. And the courtroom functions with a different procedure than any procedure that you're familiar with. You might as well be in Germany playing soccer in the German language against the best soccer team on the European continent, and someone pats you on your little pointed head and says, go out there and give them hell, Harry, because your chances of winning there are exactly 0 and none. So, since 50% of your case is wrapped up in this thing called motions, briefs, and affidavits, that's the written portion of your case, it would seem only logical and fitting to me then that we would devote about 6 hours then to this subject matter of motions. And so if you'll look on your course outline, we're going to talk about how you notice up the court, when to write, how to argue, the constitutional issues that are involved, then motions and briefs and suppression of evidence and sua sponte and Rule 4E and Rule 3 and the motion on the jury to 12 and counsel. Now that's a lot of information, and we'll have to tell you a story or two here in between and see if we can't keep you awake and alert. But motions, to make the long and short of it, are composed of 3 elements. And a motion is simply the issue that you want to raise to the court. And the next thing is then, if you got an issue, you've got to have some reason or argument behind it. They use the word argument, and I don't know if that's the right word or not, but we'll, for the sake of semantics, I guess use the word argument. It's your reasoning or your logic. You know, here's why I need this. As an example, you may be 2 weeks away from trial and you're not ready for trial yet for whatever reason. You're just not prepared. You haven't got all of your motions and arguments in. You haven't got all of your pretrial motions in. You don't have a suppression hearing completed. You've got to have more time. And so you'd file a motion with the court. And with the motion, you'd say, comes now the defendant, George Gordon, to move the court to grant 60 days of additional time to prepare the case. The defendant is not ready for trial for these causes. Number 1, you have to be specific in this. Number 1, excuse me, I have 10 more motions to file, and they are as follows. Right sua sponte, jury to 12, a brief on the jury issue, and you'd go ahead and list those. Then you'd file the motion with the court, and then you'd have to notice it up for hearing. Then you'd go in and argue it, and then the judge would decide, well, I don't know, should I give you more time or shouldn't I give you more time? And then during your oral argument, you would say, the reason you need to give me more time, Judge, is that you're rushing me to judgment, and to rush me to judgment is to deny me due process of law, and that's reversible error, and would force the court then into a new trial or a reversal of the conviction. So therefore, Your Honor, it's in the best interest of judicial expediency and cost analysis for you to give me this additional time. So there's your issue, there's your argument. Now you've got to have a couple of authorities. Issue, argument, and authority. Why is it that this judge has to give you this time. Now you would cite the Supreme Court dictionary definitions, and with these authorities, you'd say, because of Johnson versus U.S., 414 U.S. For position. Give this to me. Now the judge has to make a judicial determination. He makes a ruling. Now, it's very common for judges when they're on a real flying over issues like informations and grand juries and common law trial and right sua sponte, and you're just frying this judge alive. He'll change the subject on you. This is very common for these guys to do. They don't want to make a judicial determination. They're administrative law clerks is what they really are. They're like a clerk in a store. All he's really competent to do is to stay within the manual. He's a paid professional bureaucrat. We don't have too many judges left anymore. The judges are out in Washington. The judges are in the circuit courts and in our state Supreme Courts. But when you get down to the district court levels, you get down the traffic courts, all you've got there is clerks. You might as well just hire a woman out of business school to come in there and administer business law, because that's all you're really talking about is the Roman civil law. However, there's a process that has to be accomplished. And I know that it sounds foolish and superfluous. You know, you go in with 20 or 30 motions to dismiss and motions for grand juries and motions for this or that, and you're casting your pearls before swine is what you're really doing. Because the lower courts, while they used to, and they're commanded under the Supremacy Clause and under Marbury versus Madison to make judicial determinations on constitutional issues, they won't do it. If they do it in your state, well, that's surprising. They won't do it in Idaho. So magistrates and district court judges, they go to their manual like any bureaucrat, and they'll look down the list over here. They don't function any differently here than they do in Russia. The manual says harvest begins September 1st. There's a rainstorm. The machines go into the field and they get stuck. Well, I just went by the manual. The manual said that harvest begins on September 1st. Therefore, I did it, and therefore the bureaucrat sits back and says, well, gosh, I've done my job. See? That's the kind of foolishness that has turned the Soviet Union into a backward nation in its production. And that's the thing that we have now in the United States is bureaucracy and central planning. Now, a lot of people are pretty well attuned to that, and they're writing books and they're telling us of all the foolishness that goes on around us in economics. You can see the squandering of money. You can see it in the Pentagon. You know, every time you pick up a newspaper, what are you faced with? You've got some snafu over here. You've got the left wing put on the right side because somebody in the Pentagon fouled up, and every time they make a budget analysis, you know, this program's going to cost $3 billion. Well, I'm attuned to that. $3 billion, oh, that means $9 billion when all of the cost overruns go to it. Well, the courts work the same way. Those judges have trial judges' manuals, and they'll just go by those manuals. They will not honor your rights. They'll not go by constitutional doctrine. They can't open up Bovier's Law Dictionary and read it and get a logical and coherent decision out of it. You start going into an IRS hearing and you start quoting Supreme Court law, and they just get, their minds just snap. They can't function with that. They can't think. Well, wait a minute. Our manual says that labor is income. Doesn't make any difference. Oh, that's old law. This is a funny one. I was in court the other day, and I cited a case that was about 1852. You know, it's 120 years old or so. And this lawyer said, why, that case is that's over 100 years old, Your Honor. You know, it's obviously specious, and it's frivolous and without foundation and without merit. That's the only words lawyers know. It's specious, without foundation or merit. And it's frivolous. Yeah, that's right. Frivolous, without foundation or merit. Learn those four terms in there, and you can be a lawyer. That's right. Every time you're going to argue against a motion, you call it specious, frivolous, without foundation and without merit. Those 4 issues right there. That's your rebuttal. And then you sit down. And you could be a prosecutor. My God, you could earn $40,000, $50,000 a year, and that's the only 4 terms you need to know in law to be a prosecutor. So anyway, I'm in there, and I couldn't help but saying, well, wait a minute, maybe I'm in the wrong place here. Maybe I've misunderstood. How often do these Supreme Court decisions expire? Do they expire every 5 years? When the Supreme Court makes a decision like Miranda, my gosh, that was made in 1968. Does that mean that we can beat confessions out of people now? Because, you see, the Miranda decision expired in 1978, which was 10 years. You know, that's the expiration date. Is that the way that works? I said, well, then Hale versus Hinkle obviously expired. Oh, wait a minute. You mean Miranda is still in force? I guess it is, because these policemen still run around with these little dumb cards, and they say, you know, like any bureaucrat does, you have the right to remain silent. You have the right to counsel. You have the right to this, and you have the right to that. Oh, I was in jail not long ago, and I said, oh, you mean I have the right to counsel? Oh, well, gosh, good. Let me claim that right. Get me counsel. And the guy says, not until after you're booked. Well, after I'm booked, you'll have the admission and confession. I don't want to give you the admission and confession until I have counsel. No. You've got to be booked before you can have counsel. Then you're denying me counsel. Is that what you're telling me? No, we're not denying you counsel, but you have to give these, you have to make all the admissions and confessions before you get the counsel. Oh. See, once you've gone to the government school and you're a real true functional illiterate and you get a job with the police department, all you can function with is your little manual. That's the way these lawyers seem to be. Again, in the courtroom, it just boggles their mind. So then you go on, well, now let me see, do they expire by statute or by rule? Would you show me the statute or the rule? Well, the Supreme Court is always overturning itself. Well, I see those guys out there in Washington, you see, when they make a decision in 1920, then in 1924, they just vote against that one, and in 1928, they vote against that one, and so there's total chaos in law, and there's no way for us to know what the law is. Well, in civil law, that's true, because, you see, the legislature changes the rules every year, and you couldn't figure out for the life of you what the traffic code is this year as opposed to what it was last year or 10 years ago. Ask them those questions, you know, and you get in there. When did it expire? Gosh. I was in a tax meeting the other day, and I cited a case called Eisner versus McComber, and the guy said, well, that case has been overturned by the Garner case. It was? Gosh, I didn't know that. The Supreme Court changed the definition then of income. Is that right? Well, you know, and this poor guy's sitting there, he's getting paid, you know, I mean, he's a good public servant. He's probably been promoted to the highest level of degree of his entire competence. He's now working for the IRS. Anyway, talking to an IRS agent about constitutional law is about like talking to your dog about a ballet. I mean, it just doesn't compute with the guy. But it's necessary and imperative, so says our Supreme Court, that we exhaust every remedy within the borders of our state. So you got to go into that traffic court and you got to talk to this judge about the grand jury, about the jurisdiction, about Thibauteau versus Maine, about Title 42 when he throws you in the slammer without first establishing or asserting jurisdiction, and on it goes. And you do that by motion, by brief in support of the motion, and by affidavit. And that's the way it works. All right, with that little introduction then, let's start off here on Lesson 13. Let me read to you from Black's Fifth what the definition of some of these motions are. So if you've got a Black's Fifth, then you should follow along. If you don't, we're going to copy motions. Pull out your sheet of paper here on the subject of motions. It's over here on page 913 where it says motion. And with that, we start off. In parliamentary law, it is the formal mode in which a member submits a proposed measure or resolve for the consideration and action of the meeting. And so the courtroom is nothing more than a meeting room. And when we go into the meeting room, we have to have order. We have to have law and order. And I think that's logical and reasonable. You got a prosecutor over here, and you got you sitting over here, and the judge is there to keep order. And so you do that by making motions and briefs, and everybody speaks in his own turn. You don't have, 3 or 4 people all speaking at the same time. And this is where the order comes in. Going on then, it's an application made to a court or a judge for the purpose of obtaining a rule or order directing some act to be done in favor of the applicant. I move for dismissal, Your Honor. I move for additional time, Your Honor. All right? So the motion, or as we call it, a notice and demand at common law, a motion is the application. Judge, I want you to consider my request or my application. And that comes from a case called State v. James, Missouri, 347 Southwest. It is usually made within the framework of an existing action or proceeding and is ordinarily made on notice. But some motions may be made without notice. One without notice is called an ex parte motion. That is, that's a motion put in the court and your opponent isn't there. You probably won't ever do that. Your government does that all the time. They have ex parte hearings. Why, I had a civil case one time, and they had about 4 hearings before I ever got into the courtroom. By the time I got into the courtroom to say, wait a minute, why can't I be present at these proceedings, the judge threw me in jail for 5 days. That's the way they usually treat citizens. They treat citizens like corporations. Nevertheless, ex parte hearing, that's where you're not there and they're there. They're deciding for you. That's trial by government. They'll decide what's good for you here in the United States. Written or oral application to the court for a ruling or order, which is also called a judicial determination. Now get that word judicial determination into your vocabulary so that when the judge tries to change the subject, excuse me, Judge, we do not yet have a judicial determination on this subject of the grand jury. All I want you to do is tell me, no, we're not going to have a grand jury, but let's get it on the record, so that the appeals court can recognize the rights violation without having to go through the transcript 3 or 4 times to figure out whether or not one was ever demanded. I'm demanding a grand jury. Are we going to have one or not? No, you're not going to have a grand jury. Boy, we had a good judge up there in Spokane. Bob came back and he brought that subject up, and the judge says no. Boy, that just sets the record plainly so that when the Supreme Court sees that issue, they'll say, oh, he demanded a grand jury, and they said no. Now the question is, was he entitled to one? Okay? So that's a written or oral application to the court for a ruling or order made before motion to dismiss, during, that is a motion for a directed verdict, or after, that's a motion for a new trial, the trial. So you've got motion for directed verdict, motion for a new trial, and a motion to dismiss. And there's several other types of motions, as we'll get into here in a moment. For a requisite form of motion, see Federal Rules of Civil Procedure. Okay, now there's motions for anything you want. You can motion up the court to bring in orange juice during the trial. You can motion up the court to close the windows, open the door, and those are usually done as oral motions. Sometimes, Your Honor, I'd like to move for a recess right now so that I can confer with my counsel. I can motion for a recess because I need to go to the bathroom. I mean, those are just common sense, everyday garden variety motions. Most of the time the court will grant your motion, you know. Now sometimes they don't grant your motion and you'll have to be a little more dramatic. Your Honor, I'd like to motion for a recess. No, Mr. Gordon, we're only into the session here for 2 hours. Then you go, but Your Honor, I need to go to the bathroom real bad, you know, and just kind of squirm around a little bit, you know. Get your point across. You know, when I want a recess, I want a recess. All right, turning the page over here on page 914. Now let's just read through here quickly and get an idea of how many motions there are and some semblance of the subjects that the motions would be on. Now remember, a motion is simply the issue, and all a motion is a letter to the court. Can you write a letter to your Aunt Gertrude? Well, you can write a letter to the court. And if you'll take a look here now at, and you pick this up, this is lesson 9. Remember, this is the entire transcript of a winning case. Okay, you take a look at a motion in here, and it's got a heading, and it's got various elements to it. And we'll cover that as we go through the lesson, and we're actually going to write out a couple of these motions here. Yeah, that's right. We're going to have homework. We're going to force you to write a motion. We're going to teach you to be competent, whether you like it or not. That's what should have happened in the government school, but it didn't happen. We're so used to using the telephone, we can't write letters to Aunt Gertrude any longer. Getting back over here on page 914, right at the top of the page, here's some headings of different types of motions. Look at this. There's a motion for judgment notwithstanding the verdict. What a crazy motion. The jury comes in guilty, and you're going to motion the court to reverse the verdict? You bet. Motion for judgment on pleadings. A motion for a more definite statement. A motion for a new trial. A motion in bar. A motion in Lanine. A motion to dismiss. A motion to strike. Motion to suppress. Those are just some of the motions that you're going to make. And as you look over here, you'll see many, many more motions on all kinds of subjects, you know. Motion for grand jury. Motion for... all you're doing is saying, I want something. So, you want something, that's the issue. Here's why I want it, that's the argument. Here's the reason you have to give it to me, that's your authority. So you write up the issue, and then you sit there and say, here's why. And then you say, Blackstone says, and the Supreme Court says, and State Supreme Court says, and this court says, and this is your authority. And then the judge takes a look at this, and he says, He may direct the prosecutor to write a rebuttal. And the prosecutor will then say, no, his argument is specious, it's frivolous, it's without foundation and without merit. That's all you have to remember as a prosecutor. But as a citizen, you're going to have to learn a little more than that. So you're going to have to do a little writing, and you're going to have to learn how to write motions. So there, give you a little understanding. I'm not going to sit there and read the definitions to you. You can read those for yourself. The first thing you have to do is to notice up the court on the motions that you have. So take this spiral binder here from Lesson 9. That's a pretty thick case. You'll notice that I get real serious, you know, when I get into court. I like to win. There's nothing like winning in court. It's better than winning in chess. I'm looking at number 12. And over here at number 12 it says notice of hearing. So I'm going to give you a second here, turn to number 12, and if you'll go up here at the criminal number 25C 1167, this was a felony charge, by the way, but this is the area where in Idaho it's still in the magistrate's division, and that's why there's a different number later when it goes to the district court. And so it says notice of hearing here. And it says to, this is just form, and it says to the State of Idaho plaintiff and to Ada County prosecuting attorney. You and each of you are hereby notified that the defendant will call on for hearing his motion for withdrawal of counsel now on file in the above entitled action on the 26th day of April 1982 at the hour of 1:30 p.m. in the courtroom of the above entitled court, or as soon thereafter as counsel can be heard, dated this 21st day of April 1982, Ada County Public Defender, and it was sent in by Edward B. Odyssey, the attorney for the defendant. Certificate of mailing. Now, one of the problems that I had with this case is that the government appointed this public defender's office. That's what it was, excuse me. I didn't mean to offend anybody there. This is the public defender's office. This is one of those nifty little pieces of graft that only the judicial branch of government can come up with. This is done because the Supreme Court says you've got to have counsel. Now, because of the law enforcement growth industry, this group of counselors are licensed to take money. And they take their money from the county. They take it from the taxpayer. And so, this way, the defendant can be guaranteed that as he's going through the judicial process to be found guilty and sent to jail, that he'll be judiciously, or he will be craftily guided through the maze of the judicial process without waiving any of his rights, so that he won't have any appealable issues and he can be put in jail lawfully and legally and with the defendant's permission. We wouldn't want the defendant to be put in jail against his will and over his objection while he's kicking and screaming and demanding his common law rights. And so you appoint, that is, the court appoints the public defender to defend you. Now, that's a real misnomer. Public defenders don't win. In fact, I talked to one not long ago, and they're kind of humorous. I was out in the jail, and this fella came in. I won't mention his name because he's still around. He might get mad. And he was a public defender for 5 years down in California. And I said, well, gosh, Tony, that's interesting. And now you're in law enforcement. Yeah, you couldn't make a living as a lawyer. Well, no, I wanted to. I'm still a lawyer, and I'm still, you know, with the prosecutor's office and blah, blah. Oh, gosh, that's interesting, Tony. Tell me more about it. Well, I was in California, and I defended all kinds of weird people, you know, drug addicts and drug pushers and robbers and rapists and murderers and all kinds of guys. And boy, I just had a real good experience down there. Did it for 5 years. Oh, that's really interesting. How'd you work? Worked out of the public defender's office down in Alameda County, and it was a big office. And you know, I was one of 500 prosecutors. No, defenders. Oh, that's right. I have a hard time keeping these defenders and prosecutors and persecutors separated. You know, they all eat off the government trough, and you're paying for them all, so they're just kind of all one. Anyway, he's down there. I said, gosh, how many cases did you win? Well, actually, that wasn't our job. You know, public defenders aren't there to win. You see, they're there to represent these people, and they're all guilty anyway. You know, they're rapists and robbers and murderers and all that. Let me ask you a question. You didn't answer it. How many cases did you win? How many of those rapists, robbers, murderers, and muggers did you take into court? And, you know, just get in there like William Jennings Bryan and Clarence Darrow and just go head to head and eyeball to eyeball and toe to toe and slug it out and win that case and get that rapist back on the street. Did you ever win any of those? No. You mean you were in that public defender's office for 5 years and never won a case? No. Yeah. You know, one of the first questions you want to ask one of these public defenders when he's assigned to your case, and this will be done against your will and over your objection. Well, most people don't object, because they're so anxious to get something for nothing. You know, as soon as that judge says, are you indigent? Oh, yeah, boy, I'm really poor. And the judge says, well, then do you want a public defender at county expense and we'll pay for this guy? Oh, absolutely. Gosh, you know, it's just like food stamps. You know, it's like welfare day. You know, here it is. You get this free public defender. People just can't resist something free, can they? And so they get the public defender assigned. Believe you me, I didn't ask for this guy. I'll tell you how to get rid of these guys after they've been inflicted upon you. They're like leeches, you know. Once you get one on there, you have to extract him carefully. So, this particular guy, Odyssey, he's a real nice guy. He's appointed to my case, and I went over to his office, and I wrote up 110 questions. And I went into the office there, and I says, hi, sweetheart. Gosh, how you doing? My name's George Gordon, and the court has appointed Mr. Odyssey here as my attorney. And I thought I would come over and interview him today to determine whether or not he's competent to handle my case. And this poor girl behind the counter just blew her away. She, Mr. Gordon, are you an attorney? Oh, no, I'm the defendant. Say, well, Mr. Odyssey is representing you, and he'll probably want to interview you. Yeah. No, after I interview him. See, I haven't hired him yet. I'm not sure I want to, because I'm not sure he's competent. He might not be the kind of attorney I think I need for this case. She just kind of shook her head, and she got up and she went in, and I was ushered into this guy's office, and heck of a nice guy, you know, real likable sort of fellow. These guys are all, you know, he's got a wife and a house and a mortgage and a dog and 3 kids and a patch of grass in the front yard like all the rest of us, you know. He's just a normal run-of-the-mill guy. On Saturday, you know, you talk to him over the fence. And he's just a real likable sort of guy. The only problem is I'm sitting here facing about 28 years in the penitentiary. I kind of like to know, you know, are we going to win or lose? Am I going to prison, or am I going to be a free man to talk to you over the fence here, you know, Ed? And so I went into his office, and he said, okay, Mr. Gordon, I'm a very busy man, and I don't have much time here. He gets his pen out now. Now, Mr. Gordon, I think I've got some basic information here in your file, and, you know, he's just doing like this. And I like to be, you know, a little more calm, cool, and collected, so I just kind of watching this guy, you know. Now, Mr. Gordon, what's your defense? Well, I don't know. You're the lawyer. You're the paid professional. I kind of thought maybe you'd tell me what our defense was. Well, now, Mr. Gordon, it's just a case of talking to the prosecutor and plea bargaining this down. I'm sure that we can plea bargain this thing down to, I can see that this is a charge that's probably a pretty excessive charge. Yeah, I'd say that was probably pretty excessive, all right. Let me ask you a question here before we get started, Mr. Odyssey. How many cases like this have you won? He didn't want to answer that question, and so he evaded that by saying, well, our office is very busy, and I have about 80 cases. Well, let me ask you a question. Are you telling me that you're pretty busy? Oh, boy, we're just swamped. Okay. Well, probably look like to me that you're too busy to handle this case, in which case then maybe we should talk to somebody else, because I don't want to burden you with something that you don't have time for. Well, Mr. Gordon, I've got time to handle it, of course. I just handle it like I do all the rest, That's the problem that I'm wrestling with here. I'm afraid you're going to handle this case like all the rest. I don't want you to handle my case like all the rest. I want you to handle my case as if it was you going to prison, and I want to win. Now, are we going to win? God, friends, the conversation just broke down immediately. He looked at me kind of strangely. I was in there with 3 or 4 other people. I always like to go with witnesses. And so I reached over and I said, now, Mr. Odyssey, I've got 110 questions here. In fact, I'll tell you what I'm going to do. I'm going to send you a copy. They're in handwriting, I'm going to send you a copy of those 110 questions so that when you get a public defender assigned to your case, it'll give you an idea of some questions that you want to ask. And I told him I would like to interview you to determine your competency here in this matter. And I mean, he just come unglued. He just bounced off the walls and started biting the bushes and pawing the ground and jumping up and down. And, hey, now, Mr. Gordon, we're not, and he just... So I just sat there and I kind of observed him throw this temper tantrum, and there came a point in time when he had to sit down. And he told me how busy he was. It would appear to me, sir, that it's obvious that you don't have time for the case because you don't have time to take the test so that I can determine whether or not I want to hire you. And he just come unglued again. The county is paying for this, and you're not paying for a thing here, and blah, blah, blah. I said, excuse me, Mr. Odyssey, are you aware of Idaho statute, Title 19? And there's a code, I've forgotten it right now, that requires me to pay this money back to the county within 5 years, whether I win or lose. Were you aware of that? No. Oh, yeah, that's right. I have to pay this back whether I win or lose. So that being the case, since I'm going to pay for you in the end, and since I pay taxes, or since I rent a house that has property tax, we're paying for this, you see. I'm paying for this with my substance. And therefore, since you're getting paid by me, I want you to do what I tell you to do. Oh, listen, I'm telling you the scene that occurs when you tell this guy I want... This is a strange phenomenon in this country. The boss tells the servant what he wants him to do, and the servant jumps up and down and throws a temper tantrum. I was ushered out of his office, and anyway, you can see here on the next page, motion for withdrawal of counsel. All of a sudden, he didn't want to represent me anymore. There was something happened there. We had a little breakdown in communication. Turn the page over here. This is number 12, and it says, you'll notice up at the top, it says Ada County Public Defender, attorneys for the defendant, comes now attorney of record Edward B. Odyssey in the above entitled matter, moves this honorable court to discharge the Ada County Public Defender's Office from representing George Gordon in this matter for the following reasons. Okay, now watch his motion. Motion for withdrawal of counsel. Now you know that this is a perfect sample of a motion, now don't you? Because this guy is a competent lawyer. He's been to law school. I know this is right. Don't I? Well, let's read it with tongue-in-cheek, shall we? Idaho Code 19853A provides for appointment of a public defender for a needy person. To date, the record does not reflect any finding by the court as to the defendant's need or indigency. Yeah, that came up in the conversation. He said, are you indigent? No. I'd hire F. Lee Bailey, but I don't think F. Lee is competent to handle this case. If I thought that Lee could do this case and do it right, I'd probably hire him. And that's one of the things that I wanted to ask you about. The court, per Idaho Code 19853, is unable to appoint the public defender's office absent such a finding, and none has been made. See what I'm saying? Here's the issue. There's his argument. The court hasn't made any finding that Mr. Gordon is indigent. In fact, Mr. Gordon says that he's got the money to pay anybody he wants. I didn't say I had the money to pay anybody I want. I said I had the capacity to hire anybody I want. Number two, the defendant, George Gordon, has emphatically refused to have the public defender's office represent his interests in this or any other matter. This has been communicated to the public defender's office on and off the record. Additionally, counsel for the defendant is in an untenable position in that Mr. Gordon refuses to consider or begin to listen to any advice or counsel our office would offer. Now, that was a lie. That wasn't true at all. I think he exaggerated there. I was perfectly willing to listen to Ed's advice, but then I wanted to have the decision capacity, the opportunity to decide for myself whether or not I wanted to go that route, and he just didn't understand that for a minute. He wanted to be the attorney of record, tell me to sit down and shut up, and he'd conduct my defense. He told me so. Oh, I wanted to conduct my own defense, and I wanted him to speak for me, and I wanted him to be my counsel, and he just didn't understand that at all. These guys just don't recognize counsel. Defendant's mind is set on not allowing the public defender's office to represent his interests, and he is constantly reminding the public defender's office of the same. It is a waste of time for the public defender's office to make court appearances on Mr. Gordon's behalf when he expressly refuses our counsel on the record. Therefore, counsel prays for the court to allow the public defender's office to withdraw and respectfully request discharge of the public defender's office from representing Mr. Gordon in the above entitled matter. Dated this 21st day of April. And he came into court and he argued this position. He said, our position is absolutely untenable and blah, blah, blah. And the judge said, yeah, I think so. I think we'll just go ahead and discharge you. And Mr. Gordon, you're going to have to represent yourself pro se. And Mr. Gordon, I'm going to hold you to the same standards as a licensed lawyer. And blah, blah, blah. And this judge just laid a trip on me. I mean, he just told me where it was at. And I said, oh. Well, I see. Well, let me ask you a question here, Judge. Let me see if I understand your position here. I'll flip open my green book. A little pause for a little effect. Yes, here it is, Your Honor. The United States Supreme Court in Haynes v. Kerner decided in 1972 at 404 U.S. 519 that pro se complaints, according to the Supreme Court, are held to less stringent standards than formal pleadings by lawyers. I think, Your Honor, that you do err not understanding the law in this matter. I don't believe that you can hold me to a standard equal to a lawyer. In addition to that, I'm not here pro se, Your Honor. I'm here in propria persona. I'm here in proper person, and I'm demanding counsel of my choice, pursuant to a number of Supreme Court cases. Notably, Gideon v. Wainwright and Burgett v. Texas, Chandler v. Freitag, U.S. v. Mitchell, Reynolds v. Cochran. I think these are some of the cases that the Supreme Court of the United States has brought up. This particular judge at that point just came unglued, and he stopped there, and he threw a temper tantrum, and he just read me the riot act, and he told me which end was up. I just kind of sat there. So you just kind of sit there, and pretty soon this judge is going to run out of wind. You know, there comes a point in time, I don't know whether it's 5 minutes or 5 hours, you know, you just kind of sit there and look at this fool sitting up there on the bench reading you the riot act. Do you understand that, Mr. Gordon? That will be his last words. Or it'll come like this. Now, do you understand this, Mr. Gordon? Let me see if I understand your position, Your Honor. Is it the position of this court that I cannot have counsel? No, I just told you, I just explained to you. I'm going to appoint standby counsel, and he's going to sit over there, and we're going to put you up in this little room, and we're going to do this and that and another thing. And, excuse me, Your Honor. It would appear to me that we have a major federal question that must be resolved here in this hearing, because I'm not at all satisfied here with these proceedings. Now, I'm demanding my right to counsel, and I think that counsel is an issue that is of major federal proportions. And I think that these cases have been decided by the Supreme Court for the guidance of this court. Is this court guided in any way by the Supreme Court of the United States, or is this court a law unto itself, and it functions totally outside the scope of law and order in the United States? Well, that kind of brought him back down to earth, and he said, well, of course, we're not going to violate your rights, and we're going to make sure you have counsel, and we want to help you in every way we can. And Mr. Gordon, this is a serious charge. You're charged with a felony. Why, you could go to prison here for 20 years and blah, blah, blah. And, you know, oh, thank you very much, Your Honor. I appreciate your concern. Now, I guess the first thing we want to do is to discharge Mr. Odyssey over here. Now, let's get it on the record. Mr. Odyssey is discharged. Is that the position of the court? Well, Mr. Gordon, if you want the public defender's office discharged from this case, let the record so show. Okay, now there's your judicial determination. At that moment in time, the public defender's office is out of the case. Thank you, Your Honor.